friend remunerated the executor $1 million.
You pay 50% of the ABSD on top of that for that penalty.
Definitely walk away from it. Yeah.
Right.
You know, if your kid next time wants to sell this property away and take the monies to buy a Ferrari and get like all the hot chicks, he can do so.
All right, hi everyone. Welcome to Misheard podcast by Misfit Collective, and today we have Kelly from LiveAHome again, and also Debbie. Nice to see both of you today. Debbie, can you introduce yourself a little bit?
Sure, yeah. Hi, I'm Debbie Brittany Lim from Circular Law Chambers. I'm one of the partners there, and I practice real estate and legacy planning.
How long have you been doing this for?
Longer than how I look, probably.
Okay, hey, actually I want to know, how do you both know each other, you and Kelly?
It was true. I think one of our clients, I was in our previous film and I met your mom first.
Oh yeah,
Right.
yeah. So I actually work with my mom at her firm, and Kelly actually works with her, and that's how I met Kelly.
I think I asked your mom about the working together and about podcasts, and then she got you in. That's how I met you, and I was like, wow, this
Yeah.
gorgeous girl.
Yeah, I think my mom is like more introverted.
Yes.
So I'm a bit different from her. I don't mind doing this. Yeah.
She says let the youngsters do that.
Yeah.
Okay, great. So today we're going to talk about three things in particular. We're going to talk about trust, we're going to talk about wills, we're going to talk about the manner of holding also when it comes to estate, right? Asset, correct?
Yep.
Maybe we can start to touch a bit on trust first. Can you explain what a trust is?
So usually for trust, it would mean that a parent would purchase a property in trust for their child. So the child would then be the beneficiary, and then the parent is usually the trustee. Yeah.
So let's say, for example, right, because of the confusion that a lot of my clients have is, should they do this under trust, or they are not sure what is by way of gift. So recently, one of my clients actually asked me this question: hey, my mother-in-law wants to, gift this property to the granddaughter. Is this under trust or is this under by way of gift? What would you advise?
Okay, so first I'll ask, how old is your granddaughter? Because if the granddaughter is below 21, then it would actually have to be under trust. Because the legal age in Singapore is to hold property is 21 years old. So once you reach 21 and above, then or at least once you reach 21, you can hold property in your name. So usually for these families who consider doing this arrangement, is mainly for legacy planning purposes.
Yep.
Yeah.
I think also essentially the consideration was she didn't want to give it to the daughter because the husband and wife, they wanted to buy one property each. So they felt that maybe this property that the mom is holding is probably better to give it to the granddaughter who is 7 at this point in time.
Okay.
So
Yeah, so if they want to gift the property, one thing they need to take note is that it has to be no encumbrances on the property. So that means no bank loan, no CPF charge on it. They have to actually pay off the bank loan. They also have to refund all the CPF monies back.
Right.
Then you can gift the property.
so must be clear.
Yeah.
Right. And what kind of implication is going to happen? Like, for example, if the grandma gives it to the granddaughter and the granddaughter becomes 21, does it count as her first property already?
Yes.
So if she buys another one, she will need to pay 20% ABSD.
Yeah. So it would be based on their property count, and if they actually purchase a property in trust for the child or give the child the property, then that would consider their first property count. So maybe those that want to take the traditional route and like BTO, when they find their happily ever after, they would be shocked that they actually will not be eligible for that because they have a private property in their name already. Yeah.
Right.
I'm so sorry to interrupt. It sounds very good. There's a lot of information here, but for me, right, I should have asked this from the start. What's the difference between trust and gift? I don't know what's going on.
Oh.
Yeah.
Okay. So when you gift a property, it means, basically, to put it simply, is you already have an existing property and you just want to gift it. But gifting it, so you actually have zero monetary consideration, but you still need to pay the usual stamp duties.
Anybody can gift anything to anyone.
Yes.
As long as it's in my ownership, I can
Yeah.
gift it to anybody.
Yeah.
HDB also can?
No.
Only
Yeah.
private, yeah?
Oh,
private
private only. Oh,
Yeah.
okay. Nobody can gift HDB. My mom cannot give me her HDB.
No. No,
Oh.
not allowed. Yeah.
So-
It's HDB's property, right?
Yeah, unless you have some special approval or consent from HDB.
Has that ever happened before
So
in our history?
transferring ownership in HDB properties are only done for very exceptional circumstances. So basically, like renunciation of citizenship, death, or basic divorce, even. Yeah, but you have to have HDB approval. Yeah, but I won't comment too much because that is based on HDB rules.
Of course, understand.
Yeah.
That's true.
Okay, so what's the difference between a trust and a gift?
Okay, so for trust, you could actually purchase a property and then you purchase it in trust for a child that is below 21, meaning that you buy a new property and then you purchase it. But for gifting is you already have an existing property and then you gift this property. You can also give this property to a child that is 21 and below. So when you do that, then it's called a gift in trust.
Oh,
Yeah.
understand. And those are also subject to all the taxes and
Yeah, and there's no
service-
escaping
there's
the
no
government.
escaping that, okay.
Yeah.
Legal fee and taxes is something they
yeah.
have to pay.
Yeah.
do I always have to purchase a property having trust in mind? Or I mean, what are the pros and cons of purchasing a property with trust?
These days, because trust is 65% upfront for taxes, for stamp duty, so a lot of people are holding back on this kind of financial commitment. Although, from what we know, if you prove that this is really for trust, you might have a chance to, remit it back, case-to-case basis, because nobody can really guarantee it, right? But right now, people are holding back.
It sounds like trust has to do a lot with legacy planning.
Yes.
It's about the next generation, is it?
If I may say it, technically, yes.
But I can also purchase a property in trust for my sister. Can I?
Because it's below 21, right?
Yeah.
So we don't see a lot of such issues.
That doesn't happen.
If you're a very
hardly.
generous brother.
We don't see a lot of such cases.
No, okay.
Like 99.9% of people are all for kids.
I see. What happens if a parent purchases a property without trust? What can go wrong? Let's say, I have that. I thought even if I pass on, this property will still go to my kid anyway, right? What's the point of having...
Technically, if you pass on, your husband and wife, usually the wife becomes the first one,
Okay,
then followed by your children.
I see.
So some people will intentionally do up a will so that it's clear that this is for the kids. Right?
Yeah, so basically, most families we see actually, yes, you're right, it's for legacy planning, but it's because they want to increase their family property portfolio. So they also want to beat inflation because, property prices just keep increasing. I'm sure you know. I mean, it's good for you guys. But who knows how much like a property would cost in 10 years' time. Definitely you can't find any properties below 1 million, not too much anymore. So a lot of even my friends' parents, they actually decided to purchase the property to lock in the price so that when their children turn 21, then they are assured that their child would actually own a property by then.
Right.
So that's one thing that to take note of, and also it is useful when a parent actually wants to use a property for like investment because they feel that if they purchase this property in trust for their child and they could actually reap like maybe rental income or maybe they can actually use the sales proceeds next time to finance like their child's maintenance or education even. Yeah, so that's what we see a lot of people doing nowadays. Yeah.
So speaking of that, right, since we're talking about trust thingy, like you must assign a trustee or a trustee to
yeah.
take care of that property while the kid is below 21.
Yeah.
What kind of like things should one look out for when they assign that trustee?
Okay, so usually they could have a main trustee because usually there'll be two parents, right? So there could be a main trustee and then a replacement trustee just in case anything happens to that main trustee, he becomes bankrupt or passes away or loses mental capacity, then at least the replacement trustee can come in to manage. They also need to be prepared. We always, say that when you purchase a property in trust, it's irrevocable. So that means, your kid may look very cute at like 12, right? You don't know how they'll be when they turn 21 or 22. The property belongs to them basically after you purchase the property in trust. So you can say goodbye to your monies.
Right.
And
Right.
if your kid next time wants to sell this property away and take the monies to buy a Ferrari and get like all the hot chicks, he can do so
Right.
because it belongs to him.
So it's like I'm giving away my money to something that I'm not sure what is in for me. It's basically just free will.
It's for your love and affection to your
So we
child.
mentioned irrevocable.
Yeah.
Is there anything that we can do as a parent to not make it irrevocable?
I mean, okay, one of the conditions on getting your 65% ABSD refunded is that it has to be an irrevocable trust.
Right.
So you can actually make it revocable, but you can say bye-bye to your
65%.
Yeah, so there are a few conditions that you have to meet before IRAS actually agrees for the refund. So one of them is that it's irrevocable. You have to have an identifiable beneficiary. That means you cannot say like, for my future son. It has to be like a living, like it has to be born already.
Right.
And then, of course, you cannot put clauses that gives the trustee the power to like change or vary any of the terms inside. So they are quite stringent on that. Yeah.
I cannot give that up if a property is trusted to me. I cannot say don't wanna.
Oh, so now he's talking about the recipient.
Recipient, yeah.
I
Canada.
mean, if your parent purchased a property in trust for you and you were 12, I don't think you'll be able to even understand what's going on.
At
Maybe
21.
18,
Maybe
At 18 or
okay.
21, when I'm an adult,
18,
can
yeah.
I decide to give that up? Or can I transfer it? I can't, right? Obviously.
She's already given the rights to you. You can
Yeah.
only do it after
Yeah.
21.
Oh, so when it's mine, then I can decide what I want to do with it.
Right?
Lah.
Yeah, so basically once you hit 21, the trustee has to transfer the property to the beneficiary.
Okay.
Yeah, so that's another legal process that you
Before
have to go
21, if there's a property waiting for me in trust, ownership is not mine at all.
through. It is
Correct?
yours.
It's mine.
Yes.
Really?
It's just that the trustee, which
Yeah.
is the parent, is just holding it in trust for the beneficiary and he manages it.
So, but the name is my name.
Yeah. The
Oh.
property belongs to
But
you.
in trust, then I cannot
Yeah.
do anything until I receive it at 21.
21.
Yeah.
I see.
So what about like, let's say if I buy something for my daughter and she's like, let's say 16, for example, and it's 5 more years to her 21, then the rental, like I start renting it out.
Okay.
Or is there any regulation about where the money should go to?
Usually, they would need to set up a trust account to ensure that any rental income, any rental proceeds actually goes back into the account, because they need to be accountable for all the monies coming out or going in. Just in case IRAS does their audits, they may actually check how you are managing the monies for this trust property. Yeah.
In other words, anything pertaining to this property, actually, the trust is it trustee, right? That's what
Trustee,
you call.
yeah.
Yeah, the trustee is the one that bears full responsibility and ownership, lah.
Yeah.
Even rental and maintenance,
Yes.
repairs, everything.
Yeah.
Oh.
So that account is purely for that my future daughter in 5 years' time.
Yes. And
Ca-
all the money in the account belongs to her.
Oh.
Wow.
Can I sell a property in trust before it's transferred to the trustee?
Yes, okay, but this will also actually depend on whether the trust deed includes the terms and the power for the trustee to sell. Yeah, so it's always important to seek, legal
advice,
advice, and then ensure that whatever needs to be covered is actually included and drafted into the trust deed.
Is it expensive to purchase a property in trust in general in Singapore?
65% plus the usual tax.
No, I don't understand that. I'm so sorry. 65% of what?
Okay, so let's say you purchase a property, let's say
1 million. Yeah.
1 million, 65% 650,000.
Correct.
That alone is for that extra ABSD that you need to pay.
Okay.
And then the buyer stamp duty is still prevalent. That means it's still normal. For example, 1 million will be a 4%.
Right.
So you still need to pay by 4%.
Okay.
The 65% is you pay upfront first.
Okay.
And then we let IRAS review it and look at all the terms and conditions before they decide to release it back to you.
So when it comes to purchasing a property in trust, you mentioned something about not being able to take loan. You have to pay everything full in cash.
Yeah, full cash.
Wow.
Yeah,
Okay.
and then you also need to think about preparing the cash as well for the 65% ABSD before it gets refunded back to you. So yeah, it is quite a lot of money.
So we have like the down payments and everything,
Yeah.
full cash. Then we also have the 65%. Then we also have legal fee.
Stamp duty, legal fee,
Everything
in.
Stamp duty is the normal one, depending on how much you're buying, 4 or 5%.
Okay.
Or even 6.
Yeah, and then you talked about remission. Can we go back to that again? So when do we get that remission again?
The moment they pay the 65% stamp duties. So the moment they make that payment and they actually meet the criteria for the refund, we can actually submit the application for them.
Can you help me understand the rationale behind why there's this 65% thing? What's the rationale? Why is that
Because,
65%?
okay, so actually previously before, a few years back, there was no such thing as ABSD for trust, but the government actually, well, I guess they realized that there was a loophole. Yeah, because there were certain trust deeds that were being prepared, and then they actually made it revocable, and it defeats the whole purpose of a trust. Yeah, or perhaps they had some trust deeds that included certain terms. When my beneficiary reaches a certain age, then they have to sell the property back to me at market value, or maybe they certain stuff they couldn't. Maybe they had added in to say if my beneficiary doesn't, I'm just putting some crazy examples, doesn't bear me like a male heir by a certain age, then I will transfer the property back to myself. So I guess they realized that this defeats the whole purpose of trust. And one thing very important is that if you go into a trust arrangement, you must make sure that you do not do it for the purposes of avoiding any stamp duties. I think the conditions that IRAS has listed out to be able to meet so that they can get the refund actually make sure that ensures that they don't include all of this in the trust deed.
Right.
Yeah.
Have there been cases where the refund application failed? Do you know? Do we know?
Okay, sensitive, yeah.
Not
Is it?
from
Yeah, not from you, yeah.
not for
Yeah.
from
Yeah.
any of my
Okay.
I've not done enough trust cases
To know,
answer you
yeah.
this.
I cannot imagine like 65% then.
I think
fail,
as what she
cannot
mentions,
refund.
it depends on the
All the
terms
conditions,
and,
all the
yes.
conditions, correct. Yeah, but
If it
I can
meets
see how
anything.
it can be a loophole, so that 65% thing is
makes
very
sense,
important. It does make sense.
Basically, they're trying to say that if you really want to do this under trust, then you put money on the table and review your case. If you sincerely show me that this is for trust,
Yeah.
fair enough, I return the money back to you.
What do you think about trust when it comes to legacy planning?
Okay, so for a mother of so many children, there's this thing that I toggle as well. Like, I know that if I don't buy a property for my kid right now, it's going to be very difficult for them to buy anything when they are 20, 25 years old onwards. And even right now, as I meet a lot of clients who are 26 to 28 or even 29 years old, because of the rate of property prices going up, they need to really, use some help from the parents. And as such, sometimes they struggle with putting down their deposit because they are not sure if, even with the help from parents, are they able to finance the mortgage. Although they may have very strong income, the thing that runs through their mind is, can they really afford the mortgage that they are supposed to pay? So which explains why I notice a lot of people are going into new properties right now. Because for new properties, they are under progressive payments. So all they have to do is a down payment, which is the first 20%. And the next 5% is about during foundation period, which is 6 to 9 months down the road. That will give them some time to save money. So this is really something that I realized because right now I'm already seeing this. 5, 6, 8 or 10 years down the
from now,
road,
even worse,
it's going to be even worse. My
Yep.
kid is probably going to have that 10% and not have the
Yep.
next 15.
Yeah.
So back to the trust topic, I think if anyone was thinking of like helping our kid to invest, and if you have some surplus money or you think you can afford, it's good to
The
enter
earlier the
in.
better.
Yes,
The earlier
and
the better,
correct.
right.
Even if let's say with whatever that I can do right now, all I can do is buy one more property under trust for 2 of my girls, which is 3 and 5. Then I would have done it. Why? Because that property would have appreciated, and by the time it reaches, when they are 21, one of them, then we can make the arrangement to see how my 2 girls can, share it or something. I'm not sure yet lah, but at least one is better than none.
Yep, and I think that's a very good segue into our next topic, because you talked about purchasing a property in trust for 2 people. Can we do that? Can I purchase a property for 2 of my girls? You can.
Yeah, you can actually put two beneficiaries
Okay.
into the trust deed, but you must make sure that any of these monies that is derived from this property will be used for these two beneficiaries only.
Right.
Yeah.
And of course, then it comes down to manner of holding and how much who gets
Yeah.
when and what. Both of them won't be the same age, right? So actually very tricky, very detailed, a lot of technicalities. So can we talk a little bit about that manner of holding? What
Right.
applies where in property?
I think the interesting thing what Debbie mentioned just now is that we can put two person name for one property at the trust for the trustee, right? The thing that runs through my mind is, let's say my girl is only 3 and my other girl is 5. They will need a longer time to reach 21. So how does this work? Like, if I buy one property for my 2 girls, because of course I cannot afford 2 at the same time. So if I buy one under one girl and then for 2 girls, and then in the near future I buy one more. But right now if I buy one for 2 girls but they are different age, how do you justify which one 21 years old and when can they start taking out the money and stuff?
Yeah, so let's say you put joint tenants for both of them, okay, or tenants in common 50-50.
Okay.
Then what happens is that the moment the older one hits 21, half of that share would actually be transferred to her. So half of that property would be under her name and the other half will still be held in trust.
Right.
Yeah.
Until she's 21. Oh, that
Yeah.
can be happen.
Yeah.
So if it's joint tenancy?
Same thing. So we will just take it as 50-50 as well. Yeah. But then of course, joint tenancy, one thing about joint tenancy is that there is the right of survivorship. So if you don't have a will and you actually choose to hold your property in joint tenancy, then whoever passes away, their share will actually be given to the surviving joint owner, unlike tenants in common. Yeah, so that is one advantage of having joint tenancy.
So it depends on how my girls' relationship are.
Yeah. What's the difference between tenants in common and joint tenancy?
Okay, so joint tenancy is like a husband and wife thing. So I have like 2 groups of clients. Husband and wife, both of them are husband and wife. So one will be the traditional ones, which most of us who don't want to take risks will go for, which is joint tenancy. So what Debbie mentioned, that's right of survivorship. I don't have to worry if I never do a will or anything because by default, this gets passed down to the other
Very
person.
straightforward.
Correct.
Okay.
And it doesn't matter who contributes more or whatever as well.
In joint tenancy, is it always 50-50?
Usually.
Okay.
Yeah.
Usually.
Okay.
But what the thing it gets a bit complicated when it's a divorce case lah.
Not really. So actually, even though you hold joint tenancy, and let's say you go through a divorce, the family courts will actually take a look at various factors. So, for example, who contributed to the mortgage, who used how much CPF, was she a homemaker? Did she, give up her career to take care of the house, the kids? Oh, remember, I always tell my friends even, keep all your receipts for furniture, repair work, maintenance. It actually counts. So, if you have to go through a divorce, then, take out all your receipts. Show that you were the one who contributed more. Yeah,
I never keeps, yeah. You kept everything, Who keeps all your receipts? Why you keep Yeah, but 10 years marriage, how to keep, yeah, 10 years?
Bought my house, I just finished everything.
So we were talking halfway about joint tenancy. Joint tenancy is your very straightforward husband-wife kind of setup lah. What's tenancy in common? What's the difference?
Okay, so actually, I have a lot of young savvy couples when they purchase their first property is because they already go in knowing that they actually want to invest in a second one next time, right? But then they need to pool their finances together to even buy their first property. So usually they would then opt for tenants in common, 99-1 or even 90-10, but most of them actually go for the 99-1 because they would want to actually embark on the process called decoupling, which the legal term is called part purchase. So basically, when you actually have a 99-1 manner of holding, it makes more economical sense when the 1% shareholder exits in the future, so that this 1% shareholder can remove his name and then he's free to purchase the second property. So then in that way, they are like, increasing their family property portfolio together. Yeah. So, why we say it's more economical, right, is because when you sell this 1%, they would actually just need to base it on the value of the 1% of the property.
Right.
Yeah. And then also, stamp duties wise, the 99% shareholder would then need to only pay 1% of that buyer stamp duty.
Right.
Yeah.
Can you help me understand why then do I even need to consider this at all since it's 99.1? Why can't I just 100 lor? Husband buy, wife don't buy. Why cannot?
Because sometimes they may need to pool their finances together to even go into their first property purchase, to get a loan, or like both of them need to use their CPF funds together.
Right.
Yeah.
Understand, but the 99.1 is not taken into consideration when we're pooling finances together to purchase a property, is it?
No. Most of the time, may or may not. And
Okay.
it also depends, on the dynamic of the couple. If it's up to them. If they want, the wife can hold 99 or the husband holds 1, that's up to them. Yeah.
Okay.
If they feel comfortable with that.
So I think for my case, right, a lot of my clients, when would they consider 99.1 or 90.10? So the thing is that, like what Debbie mentions, a lot of clients who are younger these days, like 25 years onwards or maybe below 45, they are really in that property investment mindset. So if they are very sure that they are entering this property in terms of combining their income together to buy a bigger property, usually is to house the family. And then later on in the next 3 to 4 years down the road, they may have intention to
Invest.
exit and buy another one. So with this kind of family planning, we usually advise them to do 99.1.
But I have a question though. Like, so this 99.1 is taken into consideration more so when in future we want to purchase another property, then it makes sense, right? Then I can buy over that 1% share. What are the other implications though? If let's say it's joint tenancy, why can't I still buy another property next time? I can what?
Yes,
we can,
you
right? We can still decouple what? So
50%.
yeah, so why?
You need
It's
to buy
just
over that
financing lah,
50%.
that's all, is
Yeah.
it?
Yeah. It's the dollar and cents.
Okay.
So Debbie, I want to ask this on behalf of my clients.
Okay.
Because really a lot of them, they are not sure. And they are so afraid to put their manual holding as 99.1. And then they will ask me, hey, will I get into trouble or not? What if IRAS check me and stuff like that? Will I get penalized? So when I tell them 101, they are a little bit like not too sure. So this part I really want to hear from you.
Okay.
Like, what is the difference between 101 versus 99.1?
Okay, so 99.1 is actually just at the point of purchase, they go into a manner of holding, which is tenants in common 99.1, and they are joint owners. But then 101 is completely different because you actually have one owner or one person going into the purchase as a sole owner, and then after that, this person sells 1% of the share to a second individual. And then that's when you have two joint owners holding 99 and 1%. But because why IRAS actually brought this whole issue up, and it's like, quite controversial now, is because there was this loophole that usually the second owner who comes in already owns a property. And so then he actually avoids payment of the stamp duties in that way. Yeah, so let's say, if anyone suggests to you to like try to facilitate or, recommends this arrangement to you, definitely walk away from it. Yeah.
What's the penalty?
So if, let's say, IRAS does their audits, which they are, and actually finds out that you were involved in this, they will actually need you to pay the stamp duties that you were actually liable for, plus a penalty on top of that, which could be like, I think,
Hundreds
if
of
I'm not
thousands.
wrong, I think 50% additional on top of that
50% off?
of the stamp duties that you were
wow.
supposed to actually pay. If you did not actually go into this
Right.
arrangement, and
So you pay ABSD for whatever number of properties. Based on that, you pay 50% of the ABSD on top of that for that penalty,
yeah,
potentially.
yeah.
Wow.
But I'm very surprised how it became a loophole in the first place. I mean, if we're talking about property ownership and purchase, why are we not screened first to find out what properties we already have before even entering into a contract like this? Is that not the...
No, so actually, because when this person who owns 100% sells 1%, this person will only need to pay ABSD on this 1% that they purchase, as compared to when you both of them come together from the start and purchase the property together.
I see.
Then this person who
Full
already
amount of
owns,
ABSD
will pay
is liable.
100%.
Understand.
Yeah.
So the intention is to avoid.
Yeah, it's to lessen
ABSD.
lessen the ABSD lah.
Yeah.
Yeah. And tax avoidance, which is like, going into this sort of arrangements, is not a crime. So they would actually just, put penalty on you. But tax evasion,
Yep.
then that's a crime.
I see.
Yeah, so there is some
Interesting.
differences in
Okay.
that. And what's more interesting is that IRAS is starting to reward whistleblowers. Yeah, up to 100,000.
Wow.
So let's say
I
if
saw
you,
in the news.
Yeah, if you're aware that so and so did such an
Right.
arrangement, and you give information to IRAS, then they will
You get
actually
money.
reward you.
I think the whole idea why our government is coming to control all this is also to prevent property bubbling,
Oh.
Like, of course, because if they allow everyone to just buy, sell, and so readily, then it might just go back to the previous time in 2009 where you see all the people dumping their properties when market is not stable. So during that time, because of the global financial crisis, right, we noticed that it was a very big experience that our government has learned, that there was nothing to control the Singapore property. That's why people were very wary about going in. But recently, I would say these 10 years, we noticed that a lot of people are being more positive and confident about Singapore's property because of all these little regulations that our government are actively doing. That's a good thing,
It's a
actually.
good thing, yeah. What advice do you have when it comes to legacy planning? How do I know what manner of holding I should choose?
The traditional people, we just started buying a property as our first time. We don't foresee us entering into real estate as an investment tool. You just think of buying this as a home. Then I think joint tenancy is fantastic because it's really a home, The downside is that in the future, if finances get better and you want to invest, then there's a time that it might become a restriction because you need to do a 50% buy over from your other party. So if you are thinking of maybe there's a chance in the near 3, 5, 7 years down the road, I may want to keep this for my family to stay in and buy one more for investment and roll from there, then I think tenancy in common is fine. The one way I would do if I'm doing tenancy in common, which I am, is to do a will. So that will kind of cover up the portion where if I feel that I need to be a bit more well planned, then I will do a will and cover back that part.
There's no way to change my manner of holding halfway through.
I've not done it before.
You can, but stamp duties will apply again.
Oh, understand. Okay.
So you pay 2 times for that
Yeah.
50%, right?
Yeah, then you have to, if you have a loan, then you also need to, restructure
refinance
your
again,
loan. Yeah, and then, also do the whole CPF portion again. So, yeah.
So it's
it'll
not
be
like
a-
it's impossible, it's just a bit tedious
Yep.
and cost
Costs,
heavy.
yeah.
Yeah. Okay.
Actually, I want to also add in one more thing is that initially when I want to buy a property with my my partner, I'm also thinking whether should I do tenancy in common or joint tenancy, because a part of me feels that what ifs, there's a lot of what ifs ma. And then I realized the only way to overcome this is to do a will. So now I have the option to decide who I want to give my share to, and I can change it if if I decide if I have a change of plan. So I think this part is something assuring to know, and I'm starting to share with my clients on this part as well. Then the youngster ones, they are also thinking about tenancy in common because from the start, their parents start teaching them that this is what they share with me that joint tenancy is usually for HDB mostly, but if you're going to private, just start with tenancy in common. It always gives you that flexibility in case you want to do something else.
Okay, which brings us to our next topic, wills, right?
Yeah.
Having a will is very important.
Yeah.
In this day and age, I think it's quite, all the more, it's very, very important. What is a will and the importance of a will?
Okay, so I think, if you want to get a will done, definitely approach a legal professional because, nowadays there's so many online, automatic
Yeah.
template generated wills.
Do those work? Are those okay?
I mean, it's still not as watertight as having,
Right.
a professional draft it for you, and then also at least you have someone that you can discuss with, certain clauses or certain terms that you want to include in your will, because you can then, maybe discuss about your family dynamics or like how best you can actually distribute your assets, etc. So I think also the main thing is to make sure that you have mental capacity to also execute the will. And then, I think mainly, right, people want to have wills done in their lifetime because they spend so hard, they work so hard to amass all these assets. You don't want it to fall into the wrong hands. And also you don't want your family to come into dispute when you're like 6 feet down in the ground, right? Yeah, I think that's the worst thing that could ever happen. So it does give them like assurance as well. Yeah.
A will used to be very straightforward to me, but I think there are a lot of small aspects in a will that usually men tend to overlook. Like you talked about dynamics and all these small things, care to share some thoughts about that?
Okay, so the one reason why a lot of us put off writing a will is because we are really not sure how we want to distribute them. If we have a few children, sometimes you do not know how much is enough for different kids at different age. And when we want to do a will planning, we need to think about, okay, at this moment as I do the will, this is for my kid until 21. Okay, like if I'm not around, who is going to take care of my kid? And how much will my kid need at this age? As my kid progresses from age to age, let's say a childcare kid might be more heavy on milk powder, general kids snacks and enrichment classes. But then as my kid goes into primary school, there may be more tuition classes and more food and probably even get a helper for my kid. These are the things that we really need to sit down. That's the reason why Debbie mentioned you need to sit down with a lawyer to let the lawyer know that this is my concern for my kid at this age. She's only 3. Right now as I'm doing, she's 3, but I plan this for the next 5 years. What will happen? Because we always advise every 5 years you need to revisit your will because things change. Things change, like suddenly your 18 years old son may not be the lovable son anymore. You want to change your will. You see, that's the thing. So every 5 years we do the will, and the key is 3 years old and 5 years old and 7 years old might need different things at different age. You probably need to have someone to sit down and plan with you, give you some advice. You chart down all these possibilities before you decide how much each kid needs.
So a will is not that simple. It's not like when I die, my guitar go to who, my camera give who.
You can.
It's not, but it can be this detailed. Like which year I feel my child need what, I'm going to give what, where's that going to come from?
Yeah, I'm going to be very real here because if I don't do a good will, which is something that I put off for the longest time, but I know I have to do it, right? And if I do it, this will be the exact sequence I'm doing it, right? The thought process is, if I'm not around already and my son is, let's say, 21 years old, and he is given 1.5 million of money, at that age, there will be only a few likelihood. One is the people around him that he's mixing might not be really helpful for him to manage this large sum of money. Secondly, I don't know whether my family dynamics, who is going to be there for him for the right reason. Because we don't know, when it comes to money, it's sensitive.
Yep.
And thirdly, if we don't teach our kids the value of money and how to use them, I also feel that he will just squander it away. So to prevent this from happening, I think detailed planning about like, I got a 3 million asset. I give 1.5 to my son, 1.5 to my girl. That's it. This is my will. Then the key is, what if my son needs the money for future businesses, but he has spent most of them away? Can I avoid this? So we can choose to stagger the payment, stagger the payout of the amount. When he reaches 21, he can get like 200,000 to do his university and travel overseas to study. And then the balance money could be put in an investment firm or investment fund to continue rolling so that he will continually have more than 1.5 million eventually.
Right.
So I would like to think of will as this way.
A will, it sounds like a will is very flexible. It's like a blank canvas. You can almost have anything you want. But of course, you have to have somebody execute this. And that sounds like a lot of work also.
Correct. So as I mentioned, every 5 years you need to revisit your will. So the executor who is doing it, the one who is managing the asset, then and also who is going to be the guardian of your kids, all these have to be taken into consideration.
What are some dangerous things that can happen when it comes to a will, Debbie? Have you seen any cases where a will was drafted poorly or people left out some things, and what are the implications?
Well, actually, I can share one case. It's actually, there's two cases. prominent families in Singapore, and it's out in public, so you can actually just easily search on it. So actually, one of it is an example of a well-drafted will, and the other one was a badly drafted will. So, usually when there is a lot of assets, a lot of properties, after you pass on, your family could be your worst enemy, right? So one of the cases actually is about the packaging Yeos, the Yeo Hiap Singh.
Yeah.
So it was actually within his family tree. It was, I believe, the wife of the wife of the founder's grandson. Their kids, the two sons, were actually fighting over the assets. So basically, the mother, she actually had quite a few Bukit Timah landed properties in the will, and then she actually changed it a couple of times. And so eventually, she removed like her grandchildren from the will, and she actually eventually willed all her properties to her younger son, which was her favorite son. Because they actually shared in the case, the reasons why even. So basically, like, he chauffeured her to and from church, he followed her to church, he spent more time, talked very nicely to her. Whereas, like, the grandchildren, did not, I think I read somewhere, like, he didn't go to church and he didn't date a Christian girl, something like that. Yeah, and then also, like, he made her younger son the executor and removed her brother because he was getting old and he got a China national girlfriend. So she wasn't very happy about that. Yeah, quite interesting case actually. So eventually the elder brother was upset because his children was removed, right? And all the properties went to the younger brother. So the elder brother actually brought this will to court and claimed that when the mother did the changes to the will, she didn't have mental capacity then. So they brought in the lawyer who did the will for her, and also brought in doctors for like expert evidence. And then in the end, the lawyer actually confirmed that she was alert, she could give reasons. So that's why all these reasons were listed also in the case, saying why she did it. And the doctor also said even though she was depressed, she was still very like coherent, and her judgment wasn't affected. So eventually they actually upheld the will, and then the younger brother actually got all the assets. Yeah.
Wow.
As compared to this other case where this guy who's a shipping magnate, the will was badly drafted by the lawyer, and when they actually brought in the lawyer also couldn't give very good evidence. Apparently he didn't draft the will himself as well. He got a junior lawyer to do that, and there was some communication issues because this guy, he conversed in Hokkien. So I think they figured that actually the meaning of what he was trying to say was different. So eventually that will did not actually allow the older brother to get all the assets in the end, and they actually split it amongst like all the family members, under the Intestate Act. So that would actually constitute like a badly drafted will.
Right.
Yeah.
You talked about the Intestate Act.
Yeah.
Can you briefly explain a little bit more about that? So that kicks in when someone doesn't have a will, is it?
Yeah. So if you pass on without a will, then it will actually fall under the Intestate Succession Act. So actually they include like rules. They will show like who you've left behind, and then depending on who you left behind, who your assets will go to. So for example, if you just leave behind your spouse, then all your assets will go to your spouse. But if you have a spouse and you have kids, then 50% to your spouse, then the other 50% will be split equally amongst your children. So on and so forth. It's actually quite a long list. Then eventually, if you are, let's say, an orphan and you are estranged from family, you don't, no relatives
go? Yeah.
whatsoever, goes to the government.
Really?
Yeah.
Wow. I thought at least to charity or something, no?
No, that's why it's
why you
good
need a
to
will.
do a will.
Yeah.
Then you can include that.
Right. So, what other implications? I'm sure when intestate law kicks in, duration also changes, correct? I think
I
transfer.
think the important thing is I learned.
Yeah.
I saw from my client is that he didn't do a will for his situation. He doesn't have kids, single guy, and towards his last few months, I was helping him to do a transaction for his house. I didn't know he's going to go lah.
Oh.
It's after that then I know. And that was the time he started asking me a bit how to do a will, and that was like in my early days of in real estate. But later on when I learned about all the flow and all this, then he was mentioning to me that if I don't do a will now, later my money land into the hands of my aunt, don't know what and stuff like that. So I think this is something that we need to be mindful about, because you don't want your hard-earned money to land on to people that you don't want them to have your money. Like out of nowhere, suddenly you have a call, somebody say, oh, somebody left this money for you because of this intestate acts, right?
In fact, if you do a will, you can actually even include who you do not want to give your assets to. Yeah, so you can actually draft something, have your lawyer draft something to say, I've carefully considered, and my aunt will be able to take care of herself, and so that's why I will not be giving any share of my estate to her. Yeah, you can put that.
When it comes to the transferring of ownership and monies, is it this is what I hear I don't know. When you have a will, it's faster, is it? Than if the intestate act kicks in, is it?
I mean, usually grant of probate and getting a letter of administration should take around 2 to 3 months, but the advantage of having a will is that you already know the testator's true intentions and what they want you to do, and also what are the assets that they have. Because when the executor has to go to the lawyer's office to get a grant of probate or letter of administration, we also need to write to all the financial institutions. So if it is, there's no will, we don't know, the family doesn't know what they have, and sometimes they have to scramble around the deceased's room, finding what bank accounts they have, what insurance policies they have. So that would be more time consuming. And sometimes if they don't even know, then they will tell us just write to all the banks. The banks can also take a while to get back. Whereas if you have a grant of probate and they already list out what they have, it just makes the process a lot, simpler, and then less stress on the loved ones as well.
Right, side story, my father passed away 1 year plus, and it took more than 1 year to close I cannot say what bank, like a credit line,
Okay.
With no money inside one, and we don't even owe them. In fact, they owe us, he overpaid $60. And I had to spend 3,000 plus, I think, on a grant of probate just to close it, which I didn't want to, so I spent 1,800 for a lawyer to write letter, and it didn't work.
Oh.
They wouldn't budge. Yeah, they say no, you need grant of probate.
Yeah.
Even though I prove that relation and death cert, no, I can, right? I can still get a grant of probate, of course, yeah.
Yeah.
Yeah, so, but doesn't make sense, huh?
You still can get a grant of probate after if
yeah, but
you're
doesn't
not
make sense.
anymore.
But why would I spend so much to close with no money?
Yeah.
I can just leave it, every month they just send statement. I could have done that.
Yeah.
I think essentially there's also one more thing I learned from another case is when you decide to get an executor to do this for you, you really have to give them your everything, you have to give the whole list to them. My bank, which one, how many do I have? Insurance payout and CPF payout is the fastest. The rest takes a while. So what is most importantly is that we need to leave behind some money for the executor to do everything.
That's right. All these things cost money.
Yes, you need to leave behind some money that's accessible for the executor, couple of thousands or something like that, so that when they need to do this, they need the money to do this. And truth be told, you also need to set aside some money for your own wake, because the chances of your family member grieving over you, this is the last thing on their mind to scramble for money to do your wake.
Yep.
So you want to do this, it must be a full suite.
Yep. Yeah. Insurance important as well.
Insurance payout is the fastest.
CPF because you do the nomination already.
Yeah, that's right.
So that's easy. Yeah, you can't include CPF monies in your will.
Oh, is it?
Yeah. It has to go under nomination.
Oh.
Yeah.
Oh, but nomination can nominate anyone, right?
Yeah, anyone.
Okay, so similar to will. Like.
Yeah.
You had a question. You said if husband and wife die, is it? And there's no will, is it?
No, even if say it's intestate lah, then both.
Then go to the kid law, right? Or the next of kin.
No.
No, meh?
Kid first, what?
Kid first, right?
No, so they would first look at who is the older one, and then let's say if the wife, if the older one, then they will deal with her estate first, and if she did not do up a will, then it will go under intestate. So if she doesn't have kids, but she left behind her parents, then it will go to the parents. Yeah. Then thereafter, they will then deal with the husband's estate. So let's say, for example, the wife passes on first, she doesn't have parents and she doesn't have kids, then it will just go to the husband's estate.
Right.
Yeah. Then after that, they will deal with the younger one, which is the husband, and then they will see who he has left behind, if whether or not also whether he has done a will.
Okay.
Yeah.
Yeah, I think that will help a lot. That's why I must do will.
Will very important.
Yeah.
Must buy insurance.
Do will, what else? So many things to do, yeah.
We have a lot of things to do.
Yeah.
Yeah.
Yeah, you shouldn't have. Yeah.
And also choose your friends properly, because I know
Yeah.
one of my friends, well, not my friends, my mom's friends, he was actually appointed the executor of his friend's will. He never knew this, but then when his friend passed on, then he found out, okay, he is the executor. And in the friend's will, the friend remunerated the executor $1 million.
What? What?
So that's why treat your mom nicely, send her
Wow.
to church, and choose your friends wisely.
Well, I will execute Swiss, yeah. I super Swiss, yeah. Everybody I print personalized card also, you know. When
I do think this is good. This is a great idea, you know. People need to, you know, they are
Yeah.
taking the time off to handle a very important
That's true.
responsibility.
That's true.
Yeah.
Correct.
Yeah.
Yeah, but
That's
actually,
a good idea. I should
no,
do
but
it.
very rare the executors get remunerated, right?
Yeah.
Yeah, thanks
Very
for
rare,
reminding
right? I
me.
think, huh?
Yeah, usually
Yeah.
like they will choose their family member or their
Correct.
spouse or one of their children, you know.
Upon execution, right, the executor is deemed to be not in the right state of mind, like no mental capacity.
Usually two, huh?
Yeah, so usually we would tell them to appoint 2 executors and 2 trustees, then the other one can take over. But if they only appointed one, then at the point of time of the grant of probate, the court will actually look to the most relevant person. Or one of the beneficiaries, like one of the children, can also apply to be the executor. Yeah. So that's what happens.
I have a friend. His father suddenly very bad dementia, and they have no LPA. The father has fully paid up properties, and mental capacity totally gone now lah. What can he do? He can get a grant of probate for this, is it?
No, so if you have very bad dementia and the doctor certifies that you have no mental capacity, then and you say that they don't have a lasting power of attorney,
They don't.
so what they need to do is actually get a deputyship court order. Yeah, they need to appoint the most relevant person. So if his wife is still alive, not alive, then will be one of the children already, to be the deputy for him to actually manage all his affairs. Very time-consuming, complex, and costly process. That's why we always suggest, to get a lasting power of attorney, because the cost of an LPA is so much cheaper than a deputyship court order. Plus, the government is actually waiving or has waived registration fees for LPA for all Singaporeans.
Wow.
And because of COVID, they extended it, I think, I'm not sure, until like 2026 or 2028, can't remember. Yeah, but lasting power of attorney is very important.
Do they know?
No, you know what I think is more
You do it,
important?
you know.
You know what's more important, Kelly? We need a cheat sheet now. Now I need to do will, I need to do LPA, I need to do what? I don't know, so many things. How to
Yeah, we
keep
need to
up.
have like this.
we need a cheat
tick,
sheet.
check,
checklist, a checklist.
Yeah,
What
yeah.
you need in your life right now.
Yeah.
Right.
Yeah,
right,
important
right.
things.
That's
Yeah.
true. That's
Because
true.
when you're at that stage of you have no mental capacity but you're still alive and you're not dead yet,
Yeah.
you need somebody trusted to like help you make your decisions, because they will actually even make decisions on your day-to-day affairs, like who you can
Yeah.
have contact with, what you will eat, where you will stay,
Wow.
what you will wear,
Yeah.
and then after that your properties, bank
To that
accounts,
detail,
CPF.
really?
Yeah.
Wow.
Yeah.
You literally take over
A
your
bit
life.
scared, yeah.
Actually, for lasting power of attorney, let's say if you appoint your spouse, very interestingly is that the moment you divorce, it gets revoked. Yeah, by Office of the Public Guardian. Yeah, because they don't want your ex-spouse
Yeah.
to abuse the power and then use your monies or
Is that the only situation? Divorce?
divorce, death, or you
right.
become bankrupt. Yeah.
Bankrupt also?
Yeah, so if, let's say you are the donor, right? That means the person who has lost mental capacity, and then you appoint the donee, your donee becomes bankrupt, then automatically revoked, because they don't want the bankrupt to
Yeah,
go
yeah.
and, abuse and make use of the funds.
Very interesting that we have all these mechanics. I never knew that.
Yeah.
So it's quite safe in Singapore, all
Yeah,
these things.
and apparently there's also whistleblowers as well. Like if you know someone, abusing this, then report them to the OPG. But I don't know whether there's a reward for that or
Not
not.
yet. Soon.
And also maybe something to consider for ladies as well. Let's say you do a will, right? You could also put a clause to say that okay, sure, you want to give your husband all your assets, but maybe at the point of your death, if let's say you and your husband are divorced or separated at that point of time, then he gets 0.
I can choose to do that.
Yeah, you can include such
This
things.
is amazing. See? So that's why we need someone who is experienced enough
That's
to
right. Yeah,
give us
always
some
get
idea.
proper legal advice for all these things.
Yes,
lah, very
cannot do
important.
online.
Cannot. No
There's
way.
more to things that we
That's
think.
right. That's right.
Yes.
Yeah. So before we wrap up, thank you so much, Kelly from Live at Home again, and thank you, Debbie. Debbie, maybe you can tell us what you do and where you're from and what services you provide.
Okay, so I am a real estate and legacy planning lawyer. I am practicing at Circular Law Chambers, and we actually handle all sorts of practice areas. We are actually a full service law firm. So not only do we specialize in conveyancing, real estate, legacy planning, but we also have our litigation team as well. Yeah, my socials.
Yep, what are your socials?
Yeah, so I unfortunately I don't want to give in to TikTok, so I actually don't have a TikTok, but I do have Instagram. So my Instagram is Debbie Brittany. Yes.
Debbie Brittany. How do you spell Brittany again? It's okay, we'll put it there. We'll put it there.
Yeah.
Put it there.
Put it there. Yeah, we'll put it there.
AKA the Luxy lawyer.
Is that your brand? That's your brand?
Yeah.
What is Luxy Lawyer? Why Luxy?
The Luxy lawyer, because
Why the
Lawyer,
Lux-
am I right? KLB, Duffel, then father.
Okay, that's the branding. Thank you so much, Debbie. So thank you so much for being on the show again today. This has been Misheard, Misfit podcast, and also together in collaboration with Live at Home. Till next episode. Bye-bye.